go ahead and get caught up. So this letter is from Blackburn, and reply or response: Jennifer Hugh, Nika, Tanya Mirage, aka Nicki Minaj, and Kenneth Petty, Zoo, blah 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 blah. And then it goes on. We are counsel to plaintiff Jennifer Hugh in above reference matter. I am writing in response to defense counsel's docket entry 54 on about January 12th. This writing informed Mr. Bernstein that he has a scheduled conflict for February due to several pre-planned trips. This writer informed Bernstein that the initial filing of this motion should be moved to March. Mr. Bernstein agreed and suggested the following briefing schedule: March 4th for the motion, March 25th for the answer, and April 3rd for the reply. The dates offered by Mr. Bernstein worked with this writer's schedule. Unfortunately, the writer's co-counsel and former co-counsel may have conflicts with their schedules that have to be taken into consideration. However, Mr. Bernstein has not been willing to set forth the scheduling conflicts collegiately. I want to bring to the court's attention the glaringly hypocritical claim by Mr. Bernstein that the legitimate issue raised in docket entry 53 were outrageous. Throughout these proceedings, Mr. Bernstein has taken residency in the sewers of the legal profession. He has also behaved antithetical to the model rules of professional conduct, but this should come as to no surprise since he has been on the receiving end of over 10 sanction motions dating back to the early 1990s and as recent as 2018. Damn, they putting his ass out there. They basically saying this dude is full of shit because all he do is get sanctioned. An example of this deplorable behavior stems from his sick obsession with Mr. Gordon's wife. Mr. Bernstein went scrummaging through the comments section of YouTube's post in search of comments posted by Mr. Gordon. Not only was his act of cyberstalking Mr. Gordon creepily, but it was also weird and beneath the dignity of this profession. Finally, this proposed motion is nothing more than a billing exercise that serves no legitimate purpose due to the secondhand embarrassment plaintiff feels from the misguided abuse process. Plaintiff would like to apologize to the court in advance for the defendants wasting the court's time. Damn, so shit. They basically saying Bernstein's a motherfucking scumbag, and all he does is harass people, and he's been sanctioned several times dating back from 1990 to 2018. What y'all think? Does Nicki Minaj have a scumbag attorney? And then they got some exhibits here, basically backing up what they were saying. I'm not finna go through all this. I'm not finna sort this out. The gist of it is that Mr. Bernstein is, in my own opinion, this is what I get from reading the letter. You guys know, let me know what you get from reading the letter. But basically what I get is that he's a scumbag and he's been harassing and intimidating people, and basically he's been receiving sanctions going way back to the 1990s. So, he's using, these tactics that, scumbags use, right? That's what I'm getting. You guys let me know how you interpret this, right? What do you think? Do you think Mr. Bernstein is a scumbag, right? That's what I'm reading here, right? He used these unsavory tactics and he basically tries to intimidate people. That's what I read from all this. Let me know how you guys interpret this. Anyway, let's get caught up. All right, so we got a whole lot of catching up to do. And this letter is from Tysangus again, or Sangus again, however you pronounce it, right? I represent plaintiff Jennifer Hugh in above reference action. I write in response to the January 21st letter from counsel for Anika Tanya Mirage, OTM. In my January 21st letter to Your Honor, I demonstrate how OTM cannot even meet the lower standard of sanctions under Rule 11. Yet OTM's counsel is claiming to be seeking a briefing schedule for sanctions under 28 U.S.C. 1927 and the court's inherent power. If OTM cannot show that any of the plaintiff's allegations were objectively unreasonable, it is axiomatic that she cannot meet their higher standards subject to bad faith required for sanctions. On January 20th, OTM and her counsel learned that we are filing refiling against her in California. Damn, so they really coming out the decade. They coming out the decade in Cali. In Cali. So you guys let me know what you think about this. I've already admitted that I was off about this, and for the most part, I made a huge mistake when I said that they were properly served. I even made a video about that. I'll try to tag that video at the end of this video. Basically, they had a process server who just said it was basically on some bullshit. So I don't know if Tyrone basically encouraged this. I don't know if the process server basically lied to Tyrone. It looks like these guys do lie. It looks like they are on bullshit, right? You know, so anyway, you guys let me know what you think. Do you think that they should be going after Nicki? It looks like they you know, even though they dropped the case in New York, they're still going strong, and they really want to try to take Nicki down, right? And then it goes on. Hence the reason that they filed a letter with the court on the same date. This request is nothing more than an attempt to delay plaintiff's refiling against OTM. Should the court wish to hear OTM's motion, plaintiff and I request that briefing be scheduled for dates in March 2020. We also requested the court include the plaintiff's cross motion for sanctions under Rule 11 and the court's inherent power against OTM and her counsel for seeking sanction for vexatiously multiplying and delaying proceedings and for frivolously seeking sanctions based on improper purpose to harass and intimidate. Finally, plaintiff and I note that it is not merely ironic, it is telling that this case involving allegations of harassment and intimidation, OTM and her counsel have employed the same tactics in the litigation. Damn, they basically say they doing the same shit now that they did that basically started this case. With respect to my statements concerning the personal attacks, threats that I have received from OTM's counsel, I encourage the court to view Exhibit A here too, right? No person should be discouraged from seeking legal action for wrongs done to her through the use of terrorist tactics and litigation tactics. Plaintiff and I hope that Your Honor can see through OTM and her counsel's request and not to allow them to waste the plaintiff's and the court's time and resources, right? Damn. So Exhibit A, Stephen, I'm not sure you are aware of your wife's post on social media. See, this shit is, man, this is from Jude Bernstein. Who the fuck is Jude? Let's have a look at this motherfucker. I don't know if we're going to find him. I don't know if we're going to find this dude, but I want to see what he looks like. I want to see what this dude looks like. I'm not saying this is Jude. I'm not saying this is him. But he has Jude's name. Jude Bernstein, PC, New York law firm. He looks like a nice guy. He doesn't strike me as somebody that would use terrorist tactics. Damn, Jude, say it ain't so, man. I don't know if this is Nicki Minaj's attorney or not. I have the slightest motherfucking idea. But, you know, he looks like a nice guy. I don't know. You guys tell me, is this Jude Bernstein right here? Is this Jude? He is in New York. Could be him. Anyway, I mean, this is inappropriate, guys. Come on, what do you think? Do you think it's okay for an attorney to communicate to another attorney about that attorney's wife? That has absolutely nothing to do with the fucking case, right? Steven, I am not sure you are aware of your wife's posts on social media. While they raise a number of issues, I am reminding you out of courtesy that she is not covered by the litigation privilege, and to the extent she is relating discussions with you. She may have waived the marital communications privilege. There's no need for you to respond to this email because, and it doesn't really say why. My apologies in advance for any typographical and grammatical errors. Motherfucker, you can't apologize for fucking up. I am terribly a typist. I'm a terrible typist and proofreader. Just say you stupid, man. Just say you stupid, you know, but you can't apologize for being stupid. Anyway, yeah, this shit is inappropriate. He's trying to tie it to the case, but basically my own personal opinion it looks like you're basically scouring the internet for personal information, right? And then now you're trying to tie it back to the case. I don't know. I could be off on this. You guys let me know what you think. Maybe Bernstein is on point. This is all taken out of context, so I got to step back. And be careful what I say, because maybe his wife made some comments about the case on social media, and that could potentially be bad. For example, if an attorney and his wife discusses the case, and then the wife goes on social media putting stuff out there, that could be seen as a way of actually influencing the case. So maybe Jude Bernstein is right, or maybe he's just a scumbag. You guys let me know what you think. Comments below. Let's get caught up. All right, so we got another letter here. It says, "Dear Judge," and this letter is from Bernstein. Bernstein's at it again. "Dear Judge Vitaliano, I do not want to subject the court to a deluge of submissions concerning scheduling, and I certainly am not going to rise to the bait of the writer's letters demonstrating why Mr. Blackburn and Mr. Gordon are engaging in additional sanctionable conduct by sending correspondence to the court filed with false and or intentionally misleading accusations. Instead, I will respond to their accusations under oath by serving my sanctions motions on them, or filing them in court refers the motion to Magistrate Judge Cho by no later than Wednesday, January 26. If after reviewing the motion, Mr. Gordon and Mr. Bernstein believe they truly need until March to respond to it, I will consent to whatever date in March which they request." Okay, all right. Let's see what happens. So we got another, what is this? Notice of voluntary dismissal pursuant to Rule 41A1AI of the Federal Rules of Civil Procedure. Plaintiff Jennifer Hugh and her counsel hereby give notice to plaintiff voluntarily dismiss the 5th and 7th causes of action against the defendant, Kenneth Petty, and only to the extent as it relates to conduct from 2018 or later. The 4th cause of action of the amended complaint without prejudice. Now, we don't have the complaint in front of us, the amended complaint. We don't have that, but they're dismissing some of the claims, not all of the claims. Let's keep it moving. All right, let's get caught up, people. Let's get caught up. This letter is from Tsangas again, right? Somebody help me pronounce this man's name, because I can't get it, or pronounce their name. Tsangas and Associates, right? Judge Cho, my firm and I, Stephen and Gordon Esquire, are currently co-counsel for plaintiff Jennifer Hugh in the above reference action pursuant to F2 on your honor's individual practice rules. We write to the court to advise of our withdrawals. Ooh, what? Let me start over. My firm and I, Stephen and Gordon Esquire, are currently co-counsel representing plaintiff Jennifer Hugh in the above reference action pursuant to F2 of your honor's individual practice rules. We write to the court to advise of our withdrawal as counsel for plaintiff. Damn, she loses soldiers. This is not good, people. This is not good. I don't know what can be said when you have a team of attorneys and those attorneys start to drop off one by one, right? You're constantly losing attorneys. I don't know what to be said by that. It could be that those attorneys aren't getting along with each other, so therefore they decide to go separate ways. It could be that, in my personal belief, in this case, that they don't see a chance of success, so they don't want to waste their time and energy on this, so they're like, I'm up. Or it could be something else. It could be something else that I can't think of, that I'm not seeing. You guys let me know what you think. Why do Jennifer Hugh's attorneys keep jumping ship? Let me know. Like I said, it could be that, or maybe they just have bigger fish to fry, and this case is not really worth their time anymore. But I personally feel as if though they don't think there's a case. But let me just read on and see what else it says. On January 27, 2022, I was advised by written letter from lead counsel for the plaintiff, Tyrone A. Blackburn, and signed by plaintiff that my representation is being terminated. Oh, they getting rid of him. So maybe it could be that they are not getting along. Maybe they can't afford it. It could be a lot of reasons. You guys let me know what you think those reasons are. The basis for my firm and I withdrawal is also supported by New York Rules of Professional Conduct, Rule 1.16 and 11. Simply put, without revealing attorney-client privilege communications, lead counsel and I irreconcilably disagree with respect to the legal strategy moving forward. So they're not getting along. That's what I get out of this. You guys let me know, right? Because he's saying that they irreconcilably disagree with respect to the legal strategy moving forward. They have two different approaches on how they want to handle this case, so that it looks like that's the reason that they're dropping. This is by no means a reflection of any views concerning the merits of this action or any future related actions. Because I was terminated in writing by the plaintiff, and given that remaining defendant is in action has not answered the amended complaint, I have not sought consent for the same. Should the court seek to review the plaintiff's letter, I ask permission to file it under the seal for in-camera review and consideration in order to preserve the confidentiality of the attorney-client relationship. Granting motion to withdraw upon the camera review, explaining documents in support of the motions to withdraw as counsel are routinely filed under seal where necessary to preserve the confidentiality of attorney-client privileges between the party and its counsel. This method is viewed favorably by the court's internal quotations and citations omitted. Finally, given the amount of time spent working on this case, my firm and I are entitled to attorneys for our new representation date. If or when judgment or settlement is entered, I seek that fees are properly apportioned for our representation to date. It is my understanding that this will be amicably worked out between lead counsel and I at the appropriate time. If no agreement can be reached, we reserve our rights to pursue collection of such fees. So this is what I'm reading from this. It looks like, and you guys tell me, you tell me what you think, right? But it looks like he still believes that there's a chance that Hugh may win, and if they win, he want to get paid. I want to get paid, motherfucker. You basically, we don't agree, and I'm cool with that, so I'm going to step. But you're going to pay me for this motherfucking work I put into this case. You're going to pay me, motherfucker. Right? That's what I'm reading from this. So to me, that means that he thinks that there's a chance that they may prevail. All right, let me read it again. Finally, given the amount of time spent working on this case, my firm and I are entitled to attorneys for our representation to date. It should have said attorneys' fees. He just said attorneys. If or when judgment or settlement is entered, right, I seek that fees are properly apportioned for our representation to date. It is my understanding that this will be amicably worked out between lead counsel and I at the appropriate time. If no agreement can be reached, I will reserve rights to pursue collection of such fees. So I don't know. It looks like my initial thoughts on why he was withdrawing was incorrect. It looks like even though he's withdrawing, it looks like he believes that Jennifer Hugh might win. Right? You guys let me know what you think. And if Jennifer Hugh wins, he wants to get paid, goddammit. All right, let's get caught up, people. Let's get caught up. Catching up. Right? Pursuant to Rule 4A1AI, the Federal Rules of Civil Procedure, plaintiff Jennifer Hugh and our counsel hereby gives notice of plaintiff voluntary dismissal of the 5th and 7 cause of action against Kenneth Petty only to the extent it relates to conduct from 2018 or later. I think we read this already. Let's keep it moving. All right. Declaration of Tyrone A. Blackburn. I, Tyrone A. Blackburn, hereby declaring 228 U.S.C. 1746 as follows. I am the attorney duly admitted to practice in the state of New York. I am also co-counsel for plaintiff Jennifer Hugh, Mrs. Hugh in blood matter. I have personal knowledge of the facts set forth in this declaration. I submit this declaration in support of the plaintiff's motion for my entry of default judgment against defendant Anika Tanya Mirage, pursuant to Federal Rules of Civil Procedure 55B and Local Rules 55-2. What the hell? This must be old. This has to be old. why is this? So this is filed on the 28th. What the hell? How are you asking for a default judgment? I thought we were beyond that. Anyway, prior to filing this motion, I conducted an investigation into whether defendant Mirage was an active member of the military pursuant to Judge Eric N. Vitaliano Rule 3F. I searched for the defendant Mirage on the Service Member Civil Relief Act website and confirmed that she is not a member of the military, active or otherwise. I have reviewed the declaration of the plaintiff process server and proof of service affidavit for defendant Mirage. Process was properly served pursuant Federal Rules of Civil Procedures 4E. What the fuck? How are we running in circles here? I'm so confused. I am so confused because I thought it was determined already that she was not served. And pursuant to the joint letter on October 25th, 2021, the court subsequent December 8th, 2021 order for the filing of the instant motion. On August 13, 2021, this case was filed on behalf of Mirage, on behalf of Hugh. On September 2nd, 2021, Mrs. Hugh filed her first amended complaint. Prior to and after filing suit, this writer sent several emails to Onika Tanya Mirage, prior counsel Peter Ross, and called her current management team. Additionally, I contacted Kenneth Petty's current defense counsels, Hagap Kuyaminjan. I can't even pronounce that. I'm not even going to try. Michael A. Goldstein. All counsels ignored my emails. On September 15, 2021, registered process server Robert Diaz served a summons and amended complaint on Petty at his Calabasas, California home located at 23483 Park, Colombo, Calabasas. Blah, blah, blah. Process server Diaz also served a summons and amended complaint on Mirage v. Petty and subsequently mailed a copy of the summons and amended complaint to Mirage. Upon information to believe Mirage was in the Calabasas, California home listed above on September 15th. This is evidence from the Instagram live video she shot from her home that evening. That date for Mirage and Petty to answer and or move with regards to the complaint was October 6th. Mirage and Petty made the conscious decision to ignore this action on October 11, 2021, 5 days after their deadline to answer and or move with regards to the complaint. I filed a request for certificate of default from the clerk of the court on October 14, 2021. Counsel Mirage Jew Burstein made an appearance in this case on October 25th. Counsel for Petty Steve D. Isser made an appearance in this case. Petty sues the state of New York. On August 19, 2021, 6 days after Mrs. Hugh filed suit against Petty and Mirage, Petty filed suit against the state of New York, and then they give the case number. According to his August 19, 2021 court filing, Petty is domiciled in New York and has residence at whatever address. Before commencing this action, I researched property owned by the defendants and found that in 2019, Mirage transferred real property in Long Island, New York to Petty. Thus, it was reasonable to assume, at the very least, the party as husband and wife are both domiciled in New York. On October 23rd, 2021, 4 days prior to this declaration, the 2 days prior to Petty's counsel making an appearance in this case, Petty and Mirage were both in the district in Jamaica, Queens, New York. As seen on Instagram live video currently upon Mirage's Instagram page, both Mirage and Petty were seen associating with members of the Mac Ballers set of the Bloods gang. Upon information to believe, Petty and Mirage are both members of this gang. Oh man, and you know what, just because you throw up a gang sign, I don't know if that necessarily means you're a member of a gang. I can't see Nicki Minaj just doing, being a member of a gang. She just probably having fun throwing up, gang signs. People do shit like that. Doesn't mean you're a member, but hey, you guys let me know what you think. Upon information to believe, Petty can be visibly seen posting and throwing up gang signs with his fellow Mac Ballers Blood gang members. On October 23rd, 2021, shortly after Petty and Mirage are spotted on Queens, New York, a member of the gang posted a death threat to Mrs. Hugh on Twitter stating, "Jennifer, if you see this, the Mac Ballers are coming for you. All the exhibits listed in this declaration are the same exhibits in the declaration signed by me on October 27, 2021, submitted in support of Mrs. Hughes' motion for default judgment against Petty. Due to the volume of exhibits and interest of eliminated redundancy, it is incorporated herein. I declare penalty under perjury that the proceeding is true and correct. I'm sorry. Damn. So now I'm just all confused because I thought that the claim against Nicki was dismissed, but it looks like as of January 28th, this motherfucker's still trying to get a default judgment. So I'm just all confused of what's going on. If you guys know what's going on, you go ahead and let me know in the comments below. I'm still feeling that I was wrong. I'm definitely feeling that I was wrong about them being served. I still feel that they need to drop this case against Nicki and just focus on Kenneth Petty. But by Kenneth Petty actually, being in this situation where he's almost close to, I guess, completing his time on the offenders registry, it kind of feels like they need to just kind of drop that too. I don't know, guys. You let me know what you think. Do they need to just drop this whole case and just move on with their life? Or do you think they need to just stay strong and just keep fighting and just keep plucking away at this case? You guys let me know. I'm so confused right now because I thought this was dropped against Nicki. It looks like they are still in New York. It looks like they're still coming after her in California. I'm confused. I'm confused as fuck.